I hope all of you are doing great. So I have an example today to discuss with you, and you have to tell me what do you think will happen in this situation. There are two parties in a contract, X and Y. And while they enter into a contract, they mention as one of the stipulations in the contract that in case of any breach, the breaching party would be paying a maximum of 12% of the purchase value as the damages to the other party. Okay, this is mentioned in the terms of the contract and has been agreed between X and Y. Now, Y commits the breach, and X, before giving the payment, already on his own deducts the amount from the payment, which is more than the 12% mentioned in the terms of contract. And when he was asked, he tells that I have done this deduction on the basis of the principle of quantum merit. And therefore, now what do you think should be happening here? Should we impose or should we allow this, deduction that has been done beyond 12.5%? Or do you think this 12.5% is the maximum that has to now be, agreed, that has already been agreed between the parties, and that has to now be followed also? Okay, so this is related to the discussion of quasi contract, the discussion of quantum merit, which is a principle based on quasi contract, which is given under chapter 5 of the Indian Contract Act. So if you have referred to Indian Contract Act, we have chapter 5 which talks about certain provisions: 68, 69, 70, 71, and 72. These are sections which talk about how different type of agreements which are not purely a contract but resembles to that of a contract, these transactions are called as quasi contract. And that is exactly what has been discussed in the present case that I'm going to show you today. Okay, so let me take you to the case. I'll share my screen and you see that what is really happening here. So this is the name of the case, MTNL versus Tata Communication. This is 2019, decided by the Honorable Supreme Court itself. Okay. Now, exactly as I told you the facts here, MTNL and Tata had entered into an agreement. They have put a stipulation as per the liquidated damages, which has to be maximum of 12% of the purchase value. MTNL, before making the payment, before releasing the bills, already makes a deduction of a larger amount than the mentioned amount, saying and quoting that this is done for the principle of quantum merit, okay, on the basis of loss occurred. So what is quantum merit, by the way? That is the principle by which we measure the damages and we say that whatever the loss has occurred, we will follow the principle of quantum merit. Okay, now what do you think should really happen in this case? So before I show you the judgment, let me just discuss on these points. So as I told you, quasi contracts are those transactions which are not purely contract. So had it been contract, you can measure the damages by using or by applying the principle given under section 73 as well as section 74. 74 for pre-estimated damages that the parties have already agreed upon, which we see very similarly has happened in this case. 73 wherein actual or special damages that have taken place are to be measured. Okay, and that is how the confusion arose that whether the party should be allowed this or not, and they took the help of section 70. Okay, so the party which made the deduction said that we are doing this on the basis of the principle of section 70, which relies on the concept of quantum merit. So let me tell you what is section 70, and you all can read from your bare act. So while I give you an explanation, also read the language from the bare act as to what all terms are used there. For example, just a hint, okay, 68 and 69 uses the term reimbursement, while 70 uses the term compensation. So why compensation and why reimbursement has been used? You should be knowing about it, right? So 70 has certain essentials. It has to be an act which has been done non-gratuitously. The party, when they're doing it for you, are expecting that they would be paid, right? So it is done non-gratuitously. The other party to whom the benefit has occurred, they are also enjoying the benefit. That is the other essential of section 70, which has happened over here, right? But at the same time, The court takes us back and says that the underlying principle of quasi contract is that when you want a remedy under Chapter 5, you can't really assert that you are also claiming that there exists a valid contract. Okay, so quasi contract means that there is no valid contract. There is no contract that provides you damages under 73, 74, and not entirely 73. So again, the other point of discussion here is that in the judgment, the judges have highlighted that whenever we have a case of quasi contract, whenever we are getting into a situation like this where we have to measure the damages, we have the formula given under section 73 para 3. Okay, now let me show all of this to you from the judgment itself. Okay, let me share my screen with you. Yes, so now this is the name of the judgment as I had shown you, MTNL versus Tata Communications. And if you see from here, all these discussions, okay, if you read this judgment, it will be very beneficial. The judgment has certain precedents which are mentioned, which are important for judiciary aspirants, for lawyers, for students of law to know. So you can read the judgment also, okay. 14 pages will not be a lot for you to read. Secondly, if you see the summary from here, you will realize that restitution, Chapter 5, that is so mentioned here, these are quasi contract which are neither contract nor tort, and therefore the restitution is mentioned under section 73 para 3. Okay, so that is where we basically, the idea of 73 para 3 is that the measure of damages will be done as the way had there been a contract. Whatever loss would have occurred to the party is accordingly how we are going to measure the damages in a case of a contract, in case of an agreement which is not purely a contract. Okay, so that is what is discussed here. And what has been held? Section 70 cannot be availed by a person who relies on an express contract. Okay, so as I told you, this is the underlying basis where I started the discussion. I said that X and Y have a contract that they have entered into. So you can't really be making the deduction saying that I am basing it on section 70 or I am basing it on the principle of quantum merit. Okay, that is the first thing. Then therefore, the compensation quantum merit is awarded for work done or services rendered when price thereof is not fixed by the contract. Okay, when there is not a contract, then only you bring the aspect of compensation quantum merit and you make such deductions or you ask for such payment to be made. Okay, so that is one important discussion that has happened or that has taken place over here. And therefore, the court accordingly goes and decides that the liquidated damages, the amount that is so mentioned in the contract, which is governed by section 74, has to be accordingly allowed and has to be followed between the parties. Okay, so this is the summary of the judgment that I could basically share with you. I'll just take you to the judgments also. Okay, certain judgments that have been mentioned over here. We have various cases. One such case is Mulamchand versus State of MP. Very important and very, very relevant paragraph for you to understand what I just spoke about. So if you really want to understand the essence of section 70, you can read this and maybe, you can take a screenshot and keep this and read it, and you'll get a very good understanding of how the principle of section 70 has been interpreted by the judiciary. All right, so I hope this was helpful for you. I hope you got some new insights to the concept of quasi contract that you may have read or you may have understood in your college days or on your own. And I'll be back with another judgment very soon related to Contract Act. If you have any judgment wherein you do not have clarity, you can definitely drop a comment in the comment section and I'll address the same. Thank you, all of you. Have a great day.